This program is presented by University of California Television. Like what you learn? Visit our website or follow us on Facebook and Twitter to keep up with the latest UCTV programs.
Good afternoon. I think we'll probably get started. We have a lot to talk about in a limited amount of time. Thank you all for coming and welcome to the 2015 Supreme Court Review sponsored by the UCSF, UC Hastings, Consortium on Law, Science, and Health Policy. Since 2012, the consortium has put on this Supreme Court Review and assembled a panel to talk about the decisions that have come down from the court in the term that just finished. This year we're doing things a little bit differently. So we're going to try to review 4 cases today. In the past, we've tended to focus just on one and gone a little bit more in depth. So we have a challenge, and our panelists, I believe, are up to it. The Supreme Court is arguably our nation's most important institution and most powerful institution. But its workings are mysterious, or at least mysterious to those of us who are not trained in the law. Its decisions don't always seem to be evidence-based, or if they are evidence-based, they're based on a kind of evidence that us in the health professions don't immediately grasp. So even when the outcomes seem super clear, as in some ways they are this term, the Affordable Care Act is still the law of the land. Gay marriage is legal and protected. There also may be important subtleties or issues of interpretation that need to be looked at more carefully to fully understand what the court has decided. My name is Dan Doan. I'm one of the co-directors of the consortium, and we have a wonderful panel here of folks who are going to guide us through these decisions and help us understand what the court has just decided. We have about 35 or 40 minutes of comments from the panelists, and then we'll have some time for your questions and answers following that. We do have a microphone, so when we get to the Q&A part, I'll be back to try to moderate. We are recording this session, so want to ask that if you do have a question, if you could be patient and wait for the microphone to come to you, that would be super terrific. So, Jamie King is here. Jamie is professor of law and co-director of the consortium at UC Hastings. She's going to be discussing 3 cases when she makes her comments, including the ruling in the Affordable Care Act. And then John Lewis and Stuart Gaffney are here, and they're here to discuss the gay marriage decision. John is the legal and policy director of Marriage Equality USA, and Stuart is communication director also at Marriage Equality USA. Stuart's also a project director here at the UCSF Center for AIDS Prevention Studies. Stuart and John were married in San Francisco in 2004. They are superstars here at UCSF and have long been at the forefront of advocacy and action related to gay marriage and equality. So take a look at your program to learn more about these folks. I don't want to take up your time now discussing their biographies, and we want to hear from them and not from me. And so with that, I'll turn things over to Jamie to get us started.
So wow, thank you all for coming. I'm really excited to be here. What a couple of weeks it has been for the Supreme Court. Yesterday I was looking at an article about this, and an author compared the Supreme Court's recent decisions to when a player gets a finesse game in bridge, right? When even though one player is running the table, even when all the cards really aren't in their favor, they seem to be winning kind of regardless, and that's what this author seemed to be thinking was happening with the Supreme Court this term. So not every single decision this cycle has gone the way one might have wanted. There are many, many things to be thankful for, and we're going to give you some of those highlights today. So over the course of the next about 20 minutes, I have the challenge of discussing these 3 decisions with you. I will do King versus Burwell first and probably spend the most amount of time on that, and then talk more about the North Carolina State Board of Dental Examiners decision on state action immunity, and the Armstrong versus Exceptional Child Center on reimbursement in Medicaid. So, following the Supreme Court decision in 2012 in NFIB versus Subsidies, following that, the re-election of President Obama and the loss of a few Republican seats in the House, the ACA seemed to be on pretty good footing in 2013. But then we started to see challenges making their way through the courts to another key feature of the ACA, the tax subsidies. And the big question was whether or not these tax subsidies were going to actually be available to individuals who bought their plan on the federal exchange. And on July 22nd of last year, we saw two district courts, the DC Circuit and the Fourth Circuit, come down on the exact same issue about whether or not these federal subsidies applied. They came down on opposite sides of this. So the DC Circuit held that no, people who bought their plans on the federal exchange could not receive subsidies, and the Fourth Circuit held that they could. And so the King case, the Fourth Circuit case, went up to the Supreme Court. Now, as all of you know, the tax subsidies are pretty key elements of the ACA's attempt to broaden and expand access to private insurance. And these four elements, it's one of these four elements that comes up, right? So you have community rating and guaranteed issue. Community rating guarantees that everybody pays a pretty similar price, or prices for premiums on the health insurance plans are within a particular spectrum. You can't charge way more for somebody because they have been sick, right? And guaranteed issue says that insurance companies can't decline to offer insurance to somebody. So this greatly broadens access to insurance. But in order to make sure that prices aren't sky high, the ACA also imposed an individual mandate, right, requiring that everybody buy insurance. But in order to do that, you have to make insurance affordable. And so for individuals who made between 100% and 400% of the federal poverty level, the ACA offered tax subsidies to help these individuals buy insurance on the exchange. And then the exchange is sort of the linchpin in the middle of this structure to bring everything together. And so the key issue in King versus Burwell was whether these tax subsidies offered to individuals who make between 100 and 400% of federal poverty level were eligible to individuals who purchased their plans on the federal exchange. This case was brought by petitioners out of Virginia. Virginia uses the federal exchange instead of creating their own. And really these individuals, the petitioners in this case, they just didn't want to buy insurance. They didn't want to comply with the individual mandate. And they would qualify for an affordability exemption because the premiums of the insurance they would have had to buy would have constituted more than 8% of their income. So they would not have had to comply with the individual mandate if the subsidies didn't exist. But if they were eligible for the subsidies, they would have to buy insurance. And so that's really where this case came about, where these individuals didn't want to comply with the mandate. But this case was really about more than just several individuals in Virginia who didn't want to buy insurance, right? There was a lot more at stake than that. Because 34 states use the federal exchange. Only 16 states actually created a state exchange. So not only would it nullify these tax subsidies for over 6 million individuals if the individuals buying plans on the federal exchange weren't eligible for them, but also the individual mandate would be nullified for a huge percentage of individuals because they would then qualify under the affordability exemption. So about 83% of people who received subsidies, 83% of 6 million, which maybe some of you can do in your head, I cannot. So many millions of people would no longer have to comply with the mandate. And if those people didn't have to do that, then what you have with guaranteed issue and community rating is an individual insurance market where everyone has to be sold insurance, and you can buy it at any point in time, but a huge percentage of people don't have to buy it until they get sick. And when you see that situation happen, it's devastating for the market. It can create what is known as adverse selection, where people only buy insurance once they find out they're sick, and that drives up the cost overall, having more people, and then when the cost goes up, less and less people buy insurance from the outset, and it creates what is known as a death spiral. So let's look at some of the key provisions that are at issue in this case. So Section 1311 holds that each state shall, not later than January 1 of 2014, establish an American health benefit exchange. Great. But Section 1321 says that a state may elect to establish an exchange, but if the state fails to do so, the Secretary shall establish and operate such an exchange within the state. Now that's where the federal exchange gets brought into this, where the Secretary will create a federal exchange. Way further down, deeply buried in the tax code, in Section 36B, which discusses the premium assistance tax credits and who would qualify, says the premium assistance credit amount that someone would get for buying insurance on the exchange to help them is the sum of the monthly premium assistance amounts for all coverage months that they pay during that taxable year. And here's where it starts to get interesting, right? A coverage month is one in which the taxpayer is enrolled in a health plan through an exchange established by the state under Section 1311. Oops. This is just one example of what this court determined was very inartful drafting in this bill. It's throughout, but this is probably the most well-known exception. So if this is an exchange established by the state, does that mean it has to be a state exchange? Does it mean it can qualify as the federal exchange? And what does it mean by the fact that it's an exchange established by the state under 1311? If you go up to 1311, it says nothing about a federal exchange there. And this is where the problems started to arise. So the IRS comes in and says, well, given the legislative history of this, what we knew to be the goals of the act, given the entire structure of everything else, we are going to interpret this as meaning anyone who buys a plan on the state or the federal exchange. But the petitioners from Virginia disputed this, and they argued that that's not what this says. If what Congress meant was both exchanges, they could have said either an exchange established by the state under Section 1311 or the Secretary under Section 1321, or they could have just said through an exchange period. That would seem to include the state or the federal exchange. But because they included this added phrase, there is an assumption that you would like to construe that as having some meaning, right? And so that is what this case is about. So the Supreme Court got this, and anytime you're looking at a case about what did Congress mean, statutory interpretation, what is congressional intent, you look at the statute and you say, is the meaning clear? Is the statute clear or is it ambiguous? If it's clear, you just apply it as written. If the statute is ambiguous, then the court has some decision to make. Typically what happens if the statute is ambiguous, as every court that looked at this held this one was, given all the different uses and all the different points all over the act that could have applied this differently, and said, yes, the statute is ambiguous, and under a typical Chevron analysis, you would look to see whether or not an administrative agency has made an interpretation over this. So that would suggest that the IRS interpretation holding that it would apply to both state and federal agencies should control here. Now, why am I bringing up this somewhat legally technical argument? Well, what I want to point out is that that's not what the Supreme Court did, although that's what the Fourth Circuit did, which was follow the IRS interpretation and give deference to it as you would under this flowchart. Justice Roberts, in his opinion, decided that this was a case, not a case for the IRS. That this provision was too important politically and economically to be something that Congress just left for the agency, left for the IRS to fill in the gaps on. This was not something, the overarching functioning of the tax subsidies in this case were too important to the Affordable Care Act to be something that Congress just left up to the IRS. And instead, the court felt that it was important enough that it needed to accurately look at the structure of the overarching bill and make a decision about interpretation. And so what this means is that if the court is actually deciding what Congress meant here, it's making that decision sort of once and for all. It's not a decision that under a different administration, a different IRS head could interpret differently in the future. And that's probably one of the most important things to take away from this decision, is that it's no longer going to be something that's left up to the IRS, that the court really took this out of their hands. And so that's one of the big takeaways that I want you to take from this talk is sort of how that shift was done. And so when the majority looked at the overarching structure of the ACA and its attempt to broaden out access, it really felt that these provisions needed to work in tandem, that you couldn't remove the tax subsidies from 34 states and have the act function as it was originally intended. In fact, the majority quoted from Scalia, Thomas, and Alito's dissent in NFIB versus Subsidies, the first ACA case, stating that without the federal subsidies, the exchanges would not operate in the manner Congress intended and may not operate at all, right? Furthermore, the majority held that if Congress would not have such an important provision embedded in a subsection of the tax code, that if this was a function of trying to get states to really buy into creating their own exchange, Congress would have announced it a lot more formally. It would have been something that was very clearly on the table. And so, given that it felt that that was just simply not possible, as you all by now know, the court upheld the IRS's interpretation that these tax subsidies will apply to individuals buying on exchanges, whether they're in the federal or the state exchange. Of course, Scalia and Alito and Thomas dissented. It's a really entertaining dissent that I won't get into too much detail on, but I will recommend to you if you would like a good laugh, or at least to see the explicit use of applesauce. Pure applesauce is an expletive, was one of my favorites. And also the court's interpretive jiggery-pokery, and also SCOTUS care. They argue that the Supreme Court has gone to such great lengths to protect the ACA that it should be called SCOTUS care. All right, so the ACA will live to see another day. And the issue is essentially closed with respect to the federal exchanges. There's no opportunity for the IRS to come back in. I want to point out one other thing, which is that this case beyond health law is a strong sort of thumb on the lever in the court in favor of broader, more holistic, contextual look at statutory interpretation than we've seen, and really moving against the sort of strict constructionist approach that we've seen from Scalia and Alito and Thomas in the past. And so I think that's something that could have much broader legs than just looking at a case about the ACA. So what's next for the ACA? What's coming up for it? I think we will now look at how appropriations are being done, how much is being budgeted for certain provisions of it. I think this will be a big issue in terms of its viability. How it's being implemented. A lot of the ACA was being designed to look at on an iterative approach, to go out there and see what's going to work, how is it working, and then sort of cut the things that aren't working and really put emphasis and money behind the things that are working. So we'll look at implementation. There are about a dozen cases still actively in litigation about the ACA, and I would say that this case is sort of a signal that the court is growing tired of hearing cases about the ACA, and is sort of, I think if the case had gone the other way, it would have been encouragement to those other cases to bring challenges to the ACA, and the fact that it has gone this way may be a sign that everybody's ready to move beyond this. But I think the strongest thing that we need to look about in the court is, with respect to the ACA, is the 2016 election. I think that will be the last big hurdle for the ACA in terms of where it's going to stand in the United States and how long it will be here. But I think it holds. So we'll see how it does in the 2016 election. All right. Now what I'm going to do is do an incredibly fast highlight of these next two cases. So the North Carolina dental examiners versus the FTC. This is a case about the bitter competition over teeth whitening in North Carolina. Non-dentists have been offering teeth whitening services for lower prices in North Carolina, and the dentists were very upset about it. They complained to their state board, and the state board sent out 42 cease and desist letters claiming that these non-dentists were practicing dentistry in the state without a license. They also sent out letters to 11 property owners and shopping mall owners that covered 27 shopping malls in the state of North Carolina, letting them know that people who were renting their property were engaging in illegal activities. The FTC got involved in 2010, alleging that the Board of Dental Examiners in North Carolina was engaging in collusive activity to exclude non-dentists from the teeth whitening market, in violation of Section 1 of the Sherman Act and Section 5 of the Federal Trade Commission Act, and that this was an unlawful restraint of trade. Now, here's where I'm about to get into some really technical legal stuff, but what the North Carolina board claimed was that it was availing itself of a defense called state action immunity, that as a state agency, a state board, it was protected from state and federal antitrust laws. And, okay, because the state has the power to promote other goals other than competition. And so the state can do all kinds of things that regulate its market or constrain its market under powers granted to the states. But to avail itself of state action immunity from this protection from FTC enforcement, this market participant, the state, the non-entity, or a public entity that is controlled largely by market participants, as the dentistry board would be, right? The dentistry board had 10 members, 8 of them were dentists practicing in the area. So you have to show a couple of things. You have to show that the state has a clearly and expressly stated policy in favor of the regulation, in favor of letting this board regulate, and against competition. And you also have to show, more importantly, that the state is actively supervising the entity's action to ensure compliance with the policy. So there's no doubt here that the state had an express interest in regulating the quality of dental services in the state. It wants to make sure that, you know, if you're going in and you're subjecting yourself to someone sticking all kinds of needles and scary instruments in your mouth, that person is licensed and they have been through some training, right? The question in this case really comes down to not whether the state had an express policy about this, but whether it was actively supervising. And the reason why we care about whether or not they're actively supervising is you want to make sure there's political accountability. If the state is foregoing competition, right? If it's doing things that drives up the cost of teeth whitening services or would prevent there from being competition from non-dentist actors or greater opportunity to find different kinds of providers of teeth whitening services, that it's doing so in a way that the state is overseeing and really means to have happen. And in this case, the court held that the board really failed to show that its actions were supervised by the state of North Carolina in any meaningful way. And so the dentistry board could really just exclude whoever it wanted from the practice of dentistry and send them cease and desist letters. But the North Carolina wasn't really looking over them. And so this is a 6-3 decision, again, in favor of the FTC. And what you can see here is that it's exactly the same people in the majority as the King versus Burwell decision. But Scalia and Alito and Thomas's dissent raised some really important points, and some points that may have been persuasive in years past. And so I bring this up because I want to point out that I think there's a real shift with respect to the state action doctrine that's happening right now. So ordinarily, they would have held that the board is a state agency, and that would be sufficient to grant the immunity to its actions. And what we're seeing is that there's becoming a larger pushback. As we saw in the Phoebe Putney case from 2012, we're starting to see a greater amount of pushback against what state entities can do. Secondly, states have always been held to regulate the practice of medicine and have a great amount of leeway in that. And again, I think we're starting to see, obviously, some more federal involvement in the regulation of the practice of medicine. And then finally, they bring up the idea that there's a great lack of clarity in what determines who is a market participant and who can be on a board, how involved you have to be in the market, and that's a more technical point. So the implications of this case, I think, are much broader than just teeth whitening in North Carolina. I think that we're going to start to see a lot more supervision over entities governed by the state action doctrine, which has a lot to do with licensing boards of all kinds, but also entities that are regulating accountable care organizations, or if a state adopts a policy relating to integration of health entities or payment of Medicaid services and things like that. We're going to see a lot more state supervision over those kinds of entities. Secondly, this is an opportune time to review state licensing boards. I learned in preparing for this panel that there are 1,100 occupations that require a license in this country. 1,100. Everything from hair braiding to florists to shampoo specialists to interior designers and really bikini waxers, everything in between. And that this may be a time where we start to see states really evaluating whether or not this licensing is a move to restrain competition, or it generally serves a higher purpose in relationship to quality. And so we might see a lot more oversight over that, especially as the FTC starts to get involved in this. And as we start to see a move in medicine toward having individuals with a broader range of backgrounds providing medical care, this is something that is likely to come up quite seriously. And finally, I think this raises the question of the future of state action immunity. The FTC has come out pretty strongly against state action immunity when it is used in instances like these. And between this case and Phoebe Putney being victories for the federal government in those cases, I think that we have a lot, that state action immunity is going to be narrowed, much narrower than it has been in the past. And I'm happy to talk about that more in questions if you'd like, and how that might relate to ACOs. Okay, so this is going to be my 2-minute version of Armstrong versus Exceptional Child Center. This case is really a follow-on to the decision and brings some resolution to the unresolved question raised in the 2012 Douglas versus Independent Living Center of Southern California case from 2012 about whether or not the Supremacy Clause could provide an avenue to a private right of action for providers and beneficiaries to sue over low Medicaid reimbursement, right? And the question is, how can providers and beneficiaries fight in order to get their day in court to be heard about whether or not Medicaid reimbursements are too low? And so in this case, respondents who were providers of habilitation health services in Idaho sued 2 Idaho officials in the Department of Health and Welfare, complaining that the state had failed to implement new reimbursement rates, so that the state had required the Medicaid agency to come up with a new metric for Medicaid reimbursement rates. And they basically failed. They implemented it. They got a CMS waiver for those rates, but then they never actually appropriated the funds to do that. And so they're suing, claiming that the current rates, or the earlier rates, were too low, and they violated what is known as the Equal Access Provision, Section 30 of the Medicaid Act, which requires that rates be sufficient to enlist enough providers so that care and services are available under the plan, at least to the extent that such care and services are available to the general population in the geographic area. Now, we all know that there are many places in the country where Medicaid services are not available to the same extent they're available across the board. And the question is whether this provision can provide a private right of action, or whether you can use the Supremacy Clause, which says that when state laws and federal laws conflict, right, that the federal law is the supreme law of the land. So that would suggest that the Federal Medicaid Act should supersede and should preempt any kind of state law that says otherwise. And what the court basically said about this is no. No. No provider right to private reinforcement under Section 30A of the Medicaid Act. So in a 5-4 decision, the court reversed the Ninth Circuit on this, which held that the Supremacy Clause could provide that right of action. And you'll notice that this majority, this 5-4 majority, is very different than the other, right? It's Scalia, Roberts, Alito, Thomas, and Breyer. And on this one, they held that there is no implied right to action under the Supremacy Clause, no private right of action under Section 30A. And so providers and beneficiaries must file complaints for low reimbursement rates with CMS. Now, CMS, the only thing that CMS can do is threaten to withhold Medicaid funds from a state if they don't increase reimbursements. And that just doesn't happen very often. And so it's really unclear if CMS enforcement tools are going to be able to handle this challenge or do much about reimbursement rates, but it's clear from this decision that the Supreme Court is not going to go forward with it in that way. Last note, beneficiaries can sue to obtain access to some services through other provisions, but not through this one. So that is my very quick and dirty review over 3 very interesting cases that I suggest you look at or ask questions about in more detail if you'd like anything else. And I will now turn it over to Stuart and John. Thanks so much.
Thank you, Jamie, for that wonderful review of those cases. And we'll try to just hit some of the highlights of the Obergefell case so that we have some time for some questions and comments afterwards. And I'm going to talk a little bit about the legal aspects of the opinion, and then Stuart is going to talk a little bit about things that are implications for healthcare or for health and well-being. So to get right to it, Obergefell Obergefell is very likely to become one of the landmark historical rulings of the United States Supreme Court, not only because of what it says about marriage equality, but also it is a great reaffirmation of the Bill of Rights and every citizen's right to seek justice in the federal courts when governments or elected majorities trample on basic constitutional rights. And something that I think is something that's interesting about the marriage equality movement is that in one sense it's a very, very conservative movement in one way. We're talking about marriage, but in other ways it's really, really radical because it's talking about two women in a white wedding dress, right? Or two grooms. We're leaving out the bride or the groom. And the decision itself sort of reflects that in that this decision extols the virtues of marriage and talks about how really, really important it is, a keystone to our society, the great, great anchor, civilizations old. And at the same time, by saying that same-sex couples have full constitutional rights to marry, it eliminates gender from who can get married. And so we often talk about this case as the gay marriage case. But when we talk about the broad diversity of the LGBT community, lesbian, gay, bisexual, transgender, intersex, genderqueer, all the different people who make up this broad movement, now all those people, regardless of these external characteristics, you have a fundamental right under the United States Constitution to marry the person that you love and that you choose, regardless of any of that. And it's a profound statement to me of human dignity, that you are treated as a human being, and your love and your bonding with another person is given that highest recognition. And that's, to me, just a wonderful breakthrough, that we're breaking through all these classifications of people. And our highest court, and you can't quite believe it, has said, yes, you have a fundamental right to marry. So the decision talks more in terms of gay and lesbian or same-sex couples, and there are some important distinctions, if we want to get into it later, about what direct effects this might have on trans folks or intersex folks. But I want to just, again, hit some quick highlights of the legal underpinning, and one of them that I was referring to is fundamental rights. And so the decision begins with saying that everybody has a liberty to go for, and a liberty, quote, to define and express their identity. And the Constitution, in interpreting liberty, has designated certain core things that are so central to who you are as a person, to your autonomy, to your privacy, that they are fundamental. And when the government tries to burden these rights, that it must have a compelling reason to do so, and it has to be very narrowly tailored to serve that interest. And you can't be at all overbroad in what you're doing. And so this was very important, that the court recognized that same-sex couples were seeking this very well-established fundamental right to marry, just like everybody else has, essentially. And the dissent and the opponents really argued, no, this is not the marriage that everybody else has. They say it's a fundamental right to gay marriage, and you want to get gay married or lesbian married, and this is a new right. And so it's a tremendous victory, and again, looking forward, I think it's a tremendous victory to say, no. We are human beings, and we are just saying the Constitution cannot exclude us from this basic, fundamental American right. And that had not been established yet. In the DOMA case of 2 years ago, the court did not reach that question. So it's really, really important that they reach the question. And it's also really important as we look at, I am very encouraged by really, really almost uniform compliance with the decision, in every county in this vast country. And there are a few outliers. There's one county in Kentucky currently that's a little fighting going on, one in Texas, maybe a handful of others. There was a story out of Toledo, Ohio, that a judge would not marry a same-sex couple and passed it along to somebody else. But we really are seeing pretty strong compliance, and having that fundamental right, I think, is very, very valuable in fighting off potential challenges. So the other, and one other thing that I'll just mention in the fundamental rights analysis is we also won the children argument. And something that has been used to disparage LGBT people throughout American history, really, is that somehow we are a threat to children. And those of you who are old enough or have studied the history, the famous Anita Bryant Save the Children anti-gay campaigns of the 1970s. Well, Justice Kennedy reiterated what he said 2 years ago. No, the children that really need the protection here are the children of same-sex couples who are having their families demeaned and are humiliated by not having the same respect and recognition for their families. So then the other pillar of the decision is about equality and the Equal Protection Clause of the 14th Amendment. And without getting too hyper-technical here, courts review, every law can be seen as classifying people based on a trait or a characteristic, slow drivers versus fast drivers, say on a speed limit law. Or you can classify in any way when you think about it. And the way that courts examine cases, when it's a racial classification, the court gives its very highest review, the very strictest scrutiny to a law that divides people based on race. And essentially, those laws virtually always are going to be declared unconstitutional. I'm really casting with broad strokes here. And then laws reflecting gender are almost always, reflecting gender classification, they're almost always declared unconstitutional. In the court's words, there has to be, I believe, an exceedingly persuasive justification. And there's a test that's not quite as strict as racial classifications, but is still very difficult to overcome. It can be overcome because the court has recognized some biological differences. And so other laws, predominantly, the court is not going to give such a close look to, just in general, like a speed limit law, because if courts looked at every single law, they would be spending all of their time reviewing legislatures and with thousands and thousands across the country. It's completely unworkable and inappropriate. What is the sort of $64,000 question is the court has not articulated what the standard to review sexual orientation or gender identity cases. And we have won the 4 major landmark gay rights cases in the last 19 years before the court. But in those cases, they seem to be building to establishing an articulable standard that is a heightened standard, but they haven't said so exactly, and they did not say so, as many of us wish they would in this case. But they did establish some very important principles in the language. And I'm just going to give you a couple quotes of that to show how this case really does advance equality, even though they didn't sort of define if it's heightened scrutiny or not. And they talked about gay and lesbian people, not just the same-sex couples, which I think is very valuable. And the central theme of these sorts of quotations, and really the entire opinion, is human dignity. So, but here are just a couple examples. The exclusion of same-sex couples from marriage has the effect of teaching that gays and lesbians are unequal in important respects. It demeans gays and lesbians for the state to lock them out of a central institution of our nation's history, society. And that denying the right to marriage disparages the choices and diminishes the personhood of lesbian and gay people. And it works a grave and continuing harm and serves to disrespect and subordinate gays and lesbians. And not only that, for the first time, the court outlines the history in our country of discrimination against lesbian and gay people. And it talks about the years when people could not even have an identity. They could not express what was in their hearts. They could not express their love for each other. And they talk about this isolation and how so much of same-sex intimacy was a crime. And they also talked about the unfair barring from military service, government employment, immigration, even the right to gather together. So again, this principle of recognizing this historical discrimination against lesbian and gay people as a group is very important going forward. And one other note on that I will mention, and Stuart's going to follow up, is the court also seemed to recognize for the first time that sexual orientation is something that is immutable and that it is a healthy and normal thing. And this is very, very important as a legal matter in the technical ways that courts decide whether or not a group should have heightened protection under the law. And so Justice Kennedy, I think, knew exactly what he was doing when he used that word immutable in the decision twice. And so when we couple this strong language about the importance of equality with outlining that history and also showing the respect and dignity of how same-sex couples can love and commit just the same way that opposite-sex couples can, and this immutability, I think we have a very strong case, I think, in future cases that we're all concerned about, too, about employment discrimination by government, housing government, defenses to Hobby Lobby type cases. We have a very strong language to work from in this case, though it didn't quite go all the way that we had hoped for. And then finally, I'm just going to end with the conclusion, the last two sentences of the opinion, because I do think they encapsulate that and really are something that moves us forward. And that, again, extolling a little bit about how great marriage is, but the court said the hope of lesbian and gay people is, quote, not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right.
That's really beautiful. I'm in the all-important cleanup position here, which means that my remarks on the health implications of the marriage ruling stand between us and questions. So I'm going to try to be extremely concise, but please ask questions once I make time for them. I wanted to say that, and if you remembered one thing from what I'm about to say, that UCSF held a rally during the Proposition 8 campaign under the banner, "Equality is Good Medicine." And during that rally, of course, we were there as activists and voters, but also we were there to highlight that the research is really on our side. And I think that the win in the Obergefell decision really is a victory for research, and I would just like to highlight a few ways in which good medical and health policy research is integrated into the decision and the implications of it. Specifically, and John mentioned we kind of won the children argument. Well, what does that mean in terms of mental health and health? Well, we often talk about self-esteem, but of course the implications of this ruling for bullying, for suicide prevention, for reducing stigma, and the health implications of that are enormous. And I have copies here of just two of the amicus briefs in this case, one from the APHA, another from many of our professional organizations, including the APA, the AMA, and so many others, that really outline the case, both of the toll of stigma, such as, just as one example from the APHA brief, that gay men and lesbians living in states with less inclusive and protective policies are 2.5 times more likely to suffer from depression. And gay men and bisexuals living in communities with high levels of anti-gay prejudice have 12-year shorter life expectancies. That's part of the record of this case, and I think reflected in some of the soaring language of the decision. I think it's something that we who work in the intersection of health sciences and the law can really be proud of. These are very tangible policy implications here. One of the most specific ones, and John mentioned the immutability argument, but is about the growing movement to ban the practice of so-called conversion therapy. In some ways, this has gone hand in hand with the marriage equality movement. These two issues were joined in the Prop 8 trial, and actually recently a trial on consumer fraud for a conversion therapy group in New Jersey was held, and our side prevailed. Again, the Prop 8 trial is really part of the legacy of this decision, and an exhaustive 2.5-week trial in which all the research, all the experts were given a full hearing, and their testimony and their research was really integrated into Judge Walker's decision, which really is part of what has led us to this very moment in time. I want to highlight a couple ways in which the opinion really gives legal recognition to what we all feel very personally, which is the direct personal harm of prejudice and discrimination. And the opinion really verbalizes the state of inequality that we've all been living in. The majority opinion says many persons did not deem homosexuals to have dignity in their own distinct identity. A truthful declaration by same-sex couples of what was in their hearts had to remain unspoken. Outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. Wounds to our human dignity cannot always be healed with the stroke of a pen. This is not language we often expect in a Supreme Court ruling, but I think it reflects what we really feel, both the weight of inequality that we've all been living under until just over a week ago. And I don't know what it was like for you, but when this decision came down, the pure joy that people experienced, and I think honestly the relief, the kind of like a cloud has been lifted. I can't tell you how many conversations and really tearful hugs I've had with people where they were like, I'm finally equal in all 50 states. I never knew what that felt like. That's kind of what this moment is in time. I think in the interest of time, I'm not going to read to you the description of all of the rights that come with marriage. You probably know these because as activists, we've been outlining the 1,138 federal rights that come with marriage. We've been saying it over and over, but to have it enumerated in the decision, and again, I think the many health implications that follow from so many of those tangible rights is really a vindication, but also just for me and John as a married couple, this is the first time we can freely move about the country and have all these rights in all 50 states. I don't think I've even fully taken in what that feels like yet, but it's huge. I think that the implications for the next generation are even hard to contemplate. I think I would just mention on the steps of the San Francisco City Hall after we celebrated this ruling and after many beautiful things were said, John and I were just kind of collecting our things there, and there were two dads there with their newborn, and they were feeding her with a bottle, and they looked up at us, and for the first moment, they articulated what they had just realized, that she is never going to know a time when her family, her dads, were not legal in all 50 states. That's not going to be part of her conscious memory. That has ramifications for our personal well-being, our relationships, our families, our health, and for the state of our union that I think are almost unfolding and are hard to fully take in right now, but it's enormous. So equality is good medicine, and I feel like for those of us who are doing this work, whether it's as research, as activists, as lawyers, today we've all lived to have our happy ending. So thank you very much.
I want to thank the panelists for some terrific comments, inspiring, insightful. It turns out we actually have this room after 1 o'clock, so I think the experiment of doing 4 decisions in 1 hour, we've learned maybe a little challenging. But for folks who can stick around for more Q&A, I would encourage you to do so. And are there questions now? Ashley has the microphone. So if you raise your hands so Ashley can see you and I can recognize you. We're actually going to start with a subtly planted question from David Fagman, who is the founding director of the consortium and also faculty at UC.
Well, thank you, Dan. This was great. Really, really enjoyable. I was trying to think of and I did not come with a question, so hopefully this will be a fair question for all of you. But I was trying to think of a common denominator, in particular between King v. Burwell and Obergefell. And it strikes me, not to throw cold water on this wonderful moment, that the challenges ahead are really Hobby Lobby. That when you see both on the statutory interpretation issues around Burwell and the reaction nationally in the South in particular with Obergefell, it's a religious freedom argument which sets up a potential clash. And as you pointed out, Justice Kennedy, as his inclination, didn't really identify what level of review the court's going to bring to homosexuality as a class. And so I wonder if you could all comment both on the statutory interpretation issue with Burwell and the constitutional claims with Obergefell, where you see the religious freedom Hobby Lobby analysis coming out.
So I'll start just very briefly, and I'm going to assume some knowledge about Hobby Lobby for brevity here. But one of the key issues in Hobby Lobby is when somebody is claiming the religious exclusion, saying they don't have to comply with the federal law because of their religious beliefs, is whether there is a compelling government interest that can justify that burden on the personal religious belief. And Justice Kennedy, in the Hobby Lobby decision, he was one of the 5 in the majority, but he wrote a special concurrence, really explaining what Hobby Lobby was about and what Hobby Lobby did not decide. And explicitly in that concurrence, he says that employees do have concerns that are compelling under the statute. And he didn't identify what they were, and he spoke a lot about the wonders and how important, truly is, religious freedom is. But I am encouraged that he did specifically note that this is not a decision that in one stroke is just proclaiming everybody can say they have a religious reason not to follow law. And Justice Ginsburg, I think her dissent is widely credited, I think, with Alito saying this does not, mean that you can get out of race discrimination laws by saying it's against my religion not to discriminate. So I think that's, again, in the federal level, it comes down to Justice Kennedy. And that's why I am also encouraged by this soaring language about equal dignity. And he also, in the Obergefell decision, does say that the state cannot essentially impose a personal religious view on everybody. You can have your views, but when the state actually makes those views, it puts the imprimatur of the state on them, and that violates the Constitution.
If this word of Kennedy is to be taken as an indication of what will happen in the future, I'm looking at whether how long it'll be before the court decides that the issue of a fundamental right to decide what we do with our bodies at the end of life, the aid in dying thing, will be considered to have matured, ripened in the eyes of the court, now that there are 21 legislatures around the country that are pushing for the same thing that 5 states do. And do you think that the court is likely to rule differently from the way they ruled about a constitutional federal interest from the way they ruled in 1997?
Any of the panelists have a crystal ball? That's a great question.
I think it's a great question. I feel a little humbled to answer the question because we have a real what would you call it? Right to die. Yes, Rob Schwartz is in the audience, which is making me a little reluctant. But yes, I think it's a great point. I mean, I think that a lot of times these issues have to mature over time, and the more that we see a real interest in, assisted death, the more that I think, and the more states that promote it and that allow it to come forward, the more I think that we are likely to see the Supreme Court change its mind. And I honestly think it's a matter of time on that issue. Maybe a little more time, but hopefully not too much. Yeah.
And maybe our last question, Ed, do you want to?
So, on the day that the marriage equality decision came out, I happened to be working at home and saw Obama make an impassioned, beautiful speech, and then later, as I was driving to a meeting, I heard him give the eulogy. And at the end of his talk about the marriage equality decision, in a really articulate, beautiful turn of phrase, he talked about people who gained freedom, turning their hands back to reaching out to people who have yet to gain freedom. So I'm wondering if there's any augur in Justice Kennedy's decision-making that could make that tie with respect to, say, the affirmative action decisions that are coming before the court in the next session. Any tea leaf reading as to how he might make the tie in his own mind between the rights, marriage equality rights, and the rights of minority groups to gain access to equal protection?
Well, I'll just take a stab, and I think probably there are people in this room who could probably answer the question much better than I could. I'll just say this one thing about Justice Kennedy's jurisprudence is that he really embraces liberty and freedom. And if you look at what is in the Hobby Lobby concurrence, and in this case, he really likes the liberty idea, the liberty concept in the Constitution. Yeah, I'm going to just not try to fake it. I know he voted, well, in the Chute case, which is the most recent one, I'm just not enough of a scholar of his opinion and writing in that. So I will defer if somebody in the audience actually does, please.
Oh, not me. I wanted to know if David has a thought on it.
Yeah, David,
David's
please.
our constitutional law scholar.
Yes.
Justice Kennedy was in the dissent in the Grutter case. He was in the majority in the Planned Parenthood case, which was the racial balancing in the Seattle and Louisville school districts. Justice Kennedy views this issue as an equality classification problem, and so he would actually see it as consistent. His views in Obergefell, where he says that you can't classify because of the message it's sending, that's exactly the point he made in Planned Parenthood in a concurrence he wrote, that you're sending the wrong message if you classify according to race, even for affirmative action purposes. So Kennedy's position in the affirmative action context is you cannot classify on the basis of race because it sends this very negative message, which is exactly what he said in Obergefell. However, you can use proxies. You can use socioeconomic status, you can use neighborhood issues, you can use other things, but you just cannot use race. So I don't think you get Kennedy's vote. He doesn't see those things as inconsistent. His views on affirmative action, which are not in favor of upholding it as a constitutional right, and he doesn't see that as at all consistent with the same-sex marriage context.
Well, I would like to thank Ashley, and Ellen, and Jessica for making sure this happened. And the panelists who were given what clearly was an impossible task and yet did it fabulously. And thank you all for staying late.